Hello and welcome to Newscentre. I'm Parikshit Luthra. India and the United Kingdom recently concluded the 5th round of talks for a free trade agreement. Both nations are hoping to sign a landmark deal by October. The two countries aim to double bilateral trade to about $100 billion by 2030. The FTA negotiations, which began in January, have so far covered several areas including labour, trade, development and MSME. India is seeking a totalization agreement which removes dual social security taxation for IT companies, while the reduction in import duty on Scotch whisky has been among the key demands of the United Kingdom. Let me go across to our guests. We're joined by Richard Heal, the CEO of UK India Business Council. Also with us, Deep Kapuria, Chairman of the CI National MSME Council, and Poonam Gupta of the FICCI UK Council with us right now. Richard, let me begin with you. How hopeful are you for a deal by October right now? What is the status of negotiations?
Well, Parikshit, nice to see you. I'm pretty positive in relation to an agreement by Diwali, by the end of October. I know that, as you mentioned, the 5th round is just completed, but actually there is ongoing discussions. They're constant, and they're focusing really on the, if you like, the nitty-gritty of the details of various chapters. So I'm pretty positive that negotiations are being constructively approached by both parties, and that we're going to be seeing some form of resolution towards the end of October. Whether it's a total comprehensive free trade agreement, we will have to see. But I think there will be an announcement.
Right. So you are saying there will be an announcement. Poonam Gupta, from the Indian side, what are some of the submissions that the Chamber, that the Federation of Indian Commerce and Industry has made to the UK government and the Indian government as well?
Well, I know some of the key areas are basically skilled workers. There is also ask for recognition of official passports, diplomatic passports. And you've also already mentioned, Parikshit, the Scotch whisky, which is, I think, important as F&B is an important sector, especially in Scotland side of the UK. And there have been demands in terms of, easing of duties coming for, textiles and garments, for example, from India to the UK. So there are lots of sectors. Technology, we all know that India has already said that by 2070, we want to be net zero. And there are so many technologies in clean water, defense, and other sectors where both the countries can participate and take advantage of the knowledge that we have in both the countries.
Okay, let me go back to Richard at this point. Richard, which are still some of the sticky points as far as the deal goes? Has there been any consensus on tariffs on Scotch whisky? Any assurances that the UK has got from India? Also, when it comes to non-tariff barriers, any concessions that you're seeking from the Indian government?
Well, with regard to announcements as to what has been achieved or not achieved, I was informed by a senior politician that when you're playing cards, you don't necessarily announce what your hand is before actually the game has finished. So I know these things are on the table. They are important. It's a multifaceted negotiation across a huge number of things. I absolutely agree with what Poonam says in relation to some of the issues that are important. I would add to that intellectual property enforcement as well as data protection, because those are cross-cutting themes which impact on not just on the non-tariff areas, but they are very, very important.
Right. Deep Kapuria of CII is also joining us. Mr. Kapuria, give us a sense of some product lines which are absolutely important for the Indian industry if this deal has to be a win-win.
You see, Indian industry is actually quite bullish on this. It's although what we're trying to negotiate is a rather ambitious kind of FTA. But nevertheless, there are a couple of sticking points which, automatically in a number of such FTAs, wherever you go for negotiations and you have very ambitious deliverables, there will be some things or the others. And let me talk about the autos, primarily autos and auto components for that matter. And they are one of those sticking points is that can we go to a tariff reduction or whether we go to tariff elimination. A calibrated tariff reduction would be okay, but to overall elimination would be an issue. However, what is happening is the industry is getting together, and surely they are in discussion with the government and the negotiators to come out with some kind of a sectorial adjustment where both sides can win. And that's one of them. The other, of course, is the issues of spirits, whiskeys and wines, etc., where the Indian Association thinks that unless the acceptability of the maturity, which is somehow that whiskey is termed in UK, that unless it's matured by 3 years, it can't be called a whiskey. So that's what our associations are saying from our side, that they should accept 2 years. Now, whether they can be done or not done is something that we'll have to see. Now, these are two critical points, and of course, there are issues which are going to emerge in the text, like Richard said. I mean, known Richard for a while now, and we have been on both sides of the table and sometimes on the same side of the table. So we are looking forward for the actual text now to comment.
Right. Even when it came to the India-EU FTA, the tariffs that European car makers face in India had been an issue at that time as well. Do you think this time around, would the Indian industry be all right with the components and cars coming from the UK at concessional rates at lower tariffs? Would that be acceptable to the Indian industry?
See, let's differentiate between the auto components and the auto industry. As far as the auto components is concerned, we are very much there. There are a couple of items that we want tariff lines to be kept away, but more or less they're okay for calibrated, not only reduction, but also elimination of the duty. Now, as far as the CBU goes, that's a totally very, very complex issue. We have always thought that when we are trying to establish our country as something of self-reliant in terms of technology, in terms of the newer aspect of vehicles, whether they are EVs or vehicles which can have better technology, we think that tariff is inversely proportional to the technology which comes in, and that is the key. So overall, however, there are some issues of convergence. I can't reveal everything, but it seems that there is some kind of a convergence which is happening as we are talking. So hopefully something will get done to not stop this and make this a roadblock as far as the FTA goes.
All right, so you feel that there will be some compromise, some convergence to make sure that the auto sector and automotive tariffs are not a hindrance to the deal. Richard, how crucial is this agreement for the UK government? They are facing a wage crisis right now. There are economic issues, economic challenges that the new Prime Minister in the UK will also face. Do you think whether it's Liz Truss or whether it's Rishi Sunak, will the new Prime Minister like to have a rethink or take some time with this deal, or would they like to go ahead with this as soon as possible?
Well, I'm obviously not party to the thinking of either Liz Truss or Rishi Sunak, but all the mood music and what we're hearing and what we're seeing is that there is absolutely no readjustment, refocus. There is absolute commitment, and both of them have indicated in the past have indicated their support for India-UK FTA in various ways. So I'm absolutely under no illusion whatsoever that it's putting your foot to the metal and making sure that the deadlines that both Prime Minister Johnson and Prime Minister Modi set in April are going to be met. So I have absolutely no doubt whatsoever that that is the objective.
Right. Poonam, Gupta, when it comes to UK as a destination for Indian companies, how is UK compared to places in Europe? After Brexit, how is UK important from a business point of view for Indian companies?
I think UK remains very important for the Indian companies. I mean, conversations that I have with industry on both sides, there are so many Indian companies who are looking to get a footprint in the UK. In past few months, I'm seeing an increased demand in companies wanting to come, for example, and set up distilleries in the UK. They are looking to invest in companies in the UK. They are looking to see where all they can take stake in technological advancements, or, for example, in education sector in the UK. I was just reading this morning another MOU which has been signed between a UK university and one of the IIMs colleges in India to basically cooperate with each other. So I think UK, maybe it's because of the historical relationships, because of language, UK still remains a really important place to do business for a lot of Indian companies. And there is a lot of excitement from both sides where companies are watching how this FTA plans out, which opens up a really beneficial trade route for companies wanting to do business with each other.
All right. Thank you very much, Poonam Gupta, Deep Kapuria and Richard Heald, for giving us a sense of the direction that the India-UK FTA talks are taking. And from all our panelists, it seems quite clear that this deal would be done by the end of October. Thanks for watching. We're going to take a short break. Don't go anywhere. When we return, we will discuss the latest developments in the Bilkis Bano case in the Supreme Court. Welcome back. You are watching Newscentre. The Supreme Court has agreed to hear a petition challenging the remission granted by the Gujarat government to 11 convicts in the Bilkis Bano case. The court has issued a notice to the Gujarat government seeking its response in 2 weeks. The release of the convicts has drawn severe condemnation from several activists and civil rights groups. The Gujarat government said it had relied on its remission policy of 1992 to approve the applications for early release. However, as per Section 435 of the Code of Criminal Procedure, a state government shall not exercise its remission power in case the matter is being probed by the CBI, except in consultation with the central government. It is not known if the Gujarat government had consulted the centre. Bilkis Bano was 5 months pregnant when she was gang raped on the 3rd of March 2002 during the post-Gotra riots. Several of her family members, including her 3-year-old daughter, were killed by a mob in 2004. The Supreme Court ordered CBI to probe the matter. This after the National Human Rights Commission intervened and ensured legal assistance for Bano to approach the apex court. In 2004, the case was transferred from Gujarat to Maharashtra as Bano dealt with death threats. In 2008, a CBI special court upheld the conviction of 13 accused, sentenced 11 to life imprisonment. The Bombay High Court upheld the order in 2017. Joining me now to discuss this further is Abha Singh, human rights lawyer. Thank you very much for joining us. Abha Singh, give us a sense of the questions that are likely to be raised before the Supreme Court. One, of course, is what advice did the state government get from the centre? On what basis did it rely on the remission policy? Did they also need to take permission from the judge who had passed the judgment initially convicting the 11 accused? What are the big questions before the court, Abha Singh?
You know, the bench, when today it asked Gujarat government for a reply, Justice Rastogi was on the bench and he said that we are only concerned if remission was in parameters of law. And then this judge further goes on to say that merely because the act was horrific, is that sufficient to say that it is wrong? So these are the two things which Supreme Court is going to look into, that whether this remission was as part of the law, because if we go by the law, 1992 law which was passed in 1992, what were the guidelines? I would say the guidelines for remission. It said 14 years if you've completed your punishment, and in this case, death sentence was not, it was life imprisonment. And at that time, when the 1992 guidelines were prevalent, that life imprisonment meant 14 years. So it could be 14 years, and I think that is what they've said, that they've completed 14 years. But you rightly said that under 435 of the CRPC, which clearly said that if the central government is involved, in this case the CBI was involved, you should have taken permission from the central government. So now that they will have to give a reply whether CBI issue was taken or not. But what I am aghast that, what Justice Ramanna said, he said that we only said you consider it. So, but I want to say that it is the apex court, and when apex court says consider, lot of state governments go ahead and think that it is a green signal from the Supreme Court. But here Justice Ramanna clearly says that I read somewhere that the Supreme Court has granted permission for remission, but no, we only said to consider. My question is that even if such things come to the Supreme Court should not pay any attention. It should throw them out. If you see certain SLPs, when they come out of 100 belly, one is admitted. So here this was rarest of the rare. A woman was not only raped, her 3-year-old child was killed, and she was pregnant at that time. I would call it rarest of the rare. At that time, we did not have death penalty for rape. It came only after Nirbhaya 2013. So had it been that time, these people would have got death penalty. So a person who not got death penalty, you are giving him remission. That is the biggest issue.
Okay. Abha Singh, it is also being said that the remission policy of 1992 of the Gujarat government is outdated. And the manner in which these 11 accused were released on the 15th of August, they were welcomed also on their release. Do you think this raises questions?
Of course, it puts a very bad picture not only of the country but of the society, that you are garlanding rapists, you are welcoming them, men who acted like animals on a pregnant woman, who killed her 3-year-old child. It shows that the society is divided on caste lines, society is divided on religion lines, and you are ready to condone such a horrific behavior because it is you are divided on certain ideologies. This is absolutely wrong. I think it is not a good sign for the country if it is heading to such a thing. And also, why did these people accept? I think they were so feeling proud of raping a woman, proud of killing a 3-year-old child. So this itself gives a wrong signal. And in fact, I really appreciate Justice Sujata Manohar when she says that this clearly shows that there is a dilution of rule of law. So with so many activists coming forward, even the judiciary, Justice Salvi, who had read out the punishment, who gave death imprisonment, said, I was not even consulted. That is another clause. The judge who had given out, meted out the sentence, he should be consulted. But yes, the Gujarat government is going to say that we went by the 1992 policy, and it says these people had completed 14 years, so we gave them remission. Because today when the thing was going on, the bench also said, day in and day out, remission is granted to convicts of life sentence. What is the exception? So there we want to tell them, okay, you give remission. That is what Gujarat government is going to say, that day in and day out, remission is granted on 15th August, 26th January. But please remember that what you are giving out is to rapists, murderers. That is a heinous offense, rarest of the rare. So you cannot have such a policy. This policy needs to be checked. In fact, if you see in the West, you see in US, people for such heinous offenses, terror, rape, they are given 30 years, 40 years. Life means full life. And I think these 92 policy or whatever these policies are need to be set aside.
Abha Singh, I'd also like to ask you that now when it comes to Supreme Court, what has been the precedent when it comes to questioning pardons which have been granted by the governor or the president for that matter?
See, I mean, if you go by the Kehar Singh versus Union of India, the Supreme Court, this was 1989, the Supreme Court clearly said that you cannot deny a prisoner the benefit to be considered for remission of sentence, as by doing so, prisoner would have to live all his life in the prison and till the last breath without a ray of hope to be free again. And the Supreme Court said that this is against the principles of reformation, because we believe that the criminal justice system is also reformatory. Again, Supreme Court in a precedent, as you talk of, in state of Haryana versus Mahendra Singh, 2007, it said that even though no convict has a fundamental right of remission or shortening of sentence, the state, in the exercise of its executive power of remission, must consider each individual case. So then the executive here, the president and the governor, they have under Article 72 and 167 of the Constitution of India, they can pardon. But under the CRPC, it is 433 and 432 which talks of remission. But issue is, because these two cases are always quoted, Keher Singh versus Union of India and State of Haryana versus Mahendra Singh, so that is why the Supreme Court, this precarious situation has arisen.
Right. So you are saying that there are legal precedents because of which there is a precarious situation. But coming back to the facts of this present case, do you think the activists who have gone to the Supreme Court challenging the remission granted by the Gujarat government in this case, do they have a strong case? Are the facts of this case different from the other precedents that have been cited by you? Is there a strong chance or strong evidence in their case?
You know, if I go by what is the whole criminal justice system about? Justice. You know, the justice, and justice should not only be delivered, but it should appear to be delivered. So here the issue, of course, here the bench says, I mean, if a sitting judge of the bench says merely because the act was horrific, is that sufficient to say that remission is wrong? He himself is saying this, that, okay, we have to only see whether it is within the parameters of law. But my question is, this pertains to women's safety. It pertains to safety of a girl child. It pertains to when you talk of empowering the girl child, when you talk of Beti Bachao, Beti Badhao. So the message which goes that you rape a woman, you murder her child, and yet you can go scot-free. You cannot be a soft state. On one side, after Nirbhaya, you came with death penalty. So, of course, criminal justice system does not talk of retrospective effect, and that is why they have been benefited under the 1992 policy, not under the 2014, which talked of life imprisonment, which also meant your good life, your full healthy life. So, of course, this is going to be a tricky situation, but my question is, the activists are very right in going to the Supreme Court, because the justice is enraged. Your rule of law is not followed, because number one, you did not take the permission, you did not take the decision or the advice of the judge who gave the sentence. Then what I have read among the papers, that the people who were on the committee belong to a particular ideology. So these things, you have to be transparent, you have to be fair, and for a heinous offense, you give remission for people. In fact, even during COVID, when the Supreme Court talked of commuting sentences or reducing sentences, it said people who were going under, who were under imprisonment for a punishment which was up to 7 years. But here, this is such a serious matter. So I think the court should, they have the powers to reject this remission and ensure that these people are rearrested.
All right. Thank you very much for putting the legal precedents and the facts of this case before us, Abha Singh. With that, it's a wrap on this edition of Newscentre. Thank you for watching. Goodbye.